People assume that ending a binational marriage is like breaking a plate. One solid strike from a judge, and the two halves cleanly split apart forever. You hire an attorney in Manhattan, you go through the courts, get the final decree signed, and you walk out onto Broadway feeling like a legally single person. Or maybe you file in London. The judge stamps your papers, the financial settlement is logged, and you think the paperwork is behind you. Then you fly down to Sao Paulo to sell the apartment you bought together. That's when the notary looks at your foreign decree and shakes their head. Here, none of it matters. You've entered the invisible marriage. You are legally single in the US or the UK, but under Brazilian law, you are still married. You cannot sell your Brazilian real estate, and you cannot legally remarry there. That Manhattan decree has zero legal weight in South America until it goes through a formal recognition process at Brazil's highest non-constitutional court, the Superior Tribunal de Justiça. This brings us to a strict rule of Brazilian civil procedure called Lex Rei Cite. Brazilian courts have absolute, exclusive jurisdiction over real estate located within their borders. If a judge in London or New York tries to order the sale or transfer of your apartment in Belo Horizonte, that order is legally void in Brazil. Until you take specific action to bridge these two systems, your assets remain completely exposed. This legal trap is triggered by three very specific variables: owning physical assets in Brazil, having children living there, or having a spouse who is domiciled there. If any of those are true, the separate systems collapse into a single bottleneck: the jurisdictional conflict. You have two main ways to resolve this. Path A is filing directly in Brazil from the start. Path B is finalizing the divorce in your home country first, then getting it recognized in Brazil later. Cross-border legal issues are battles over jurisdiction. Choosing the wrong path right now dictates how much time, money, and asset control you will forfeit over the next few years. Let's look at Path A. You bypass your home country entirely and submit the whole divorce to the Brazilian family court system. The main benefit here is power. You gain direct, immediate, unified judicial control over your Brazilian real estate, bank accounts, and in-country custody arrangements without waiting for international enforcement. But you lose your home country's flexible, equitable distribution rules. You become subject to Brazil's default property laws, which typically mandate a strict 50-50 split of any assets acquired during the marriage, regardless of who earned what. If your spouse lives outside Brazil, you have to serve them notice internationally. That specific piece of bureaucracy routinely stalls the process by 3 to 12 months before the case even really begins. Path A is the most powerful tool you have for absolute asset control, but you have to accept rigid local property divisions and the reality of international court delays. Now for Path B. You get a final decree in the US or UK. Then you pay for sworn Portuguese translations, apostille certifications, and STJ filing fees to bring it to Brazil. Brazil officially recognizes the foreign document and updates your civil status to divorced. You are free to remarry or move on. Here is the reality of the timeline. The STJ homologation process takes an additional 3 to 12 months, and that clock only starts after your foreign divorce is completely finished. The real trap is that homologation does not divide Brazilian real estate. Because of Lex Rei Cite, you have to file a mandatory secondary lawsuit in Brazil, a sober partilha, just to execute the property split. Path B lets you use familiar home country laws to negotiate the core separation, but if there is a Brazilian property involved, it guarantees you a dual lawsuit nightmare. There are two extreme outliers to this process. The first is the speed exception, the extrajudicial cartorio divorce, which finalizes the separation administratively in just 2 to 6 weeks. It is incredibly fast, but the constraints are rigid. You need absolute 100% agreement between both spouses, flawless apostilled paperwork, and no minor children. If absolute agreement is impossible and your assets are at risk, you need the opposite approach, the emergency asset play, using Brazil's cautelar measures. You pay upfront legal fees to file an urgent judicial protest directly on your Brazilian property's public deed. This legally blocks a hostile spouse from selling or transferring the apartment behind your back. Hyperspeed requires total, uncompromising peace. Protecting exposed assets requires striking aggressively before the opposing spouse realizes the marriage is over. Map asset complexity against spousal cooperation. High cooperation, low complexity, you're the speed-focused diplomat. Use the Cartorio route. Divorced abroad? You're the already divorced expat. Start STJ homologation. Low cooperation, high stakes? You're the protective parent. File in Brazil first to secure deeds and children. Whatever you do, do not allow uncoordinated parallel lawsuits to proceed in two different countries simultaneously. A concession made in New York will ruin your position in Sao Paulo. A cross-border divorce requires a singular, coordinated strategy. Make sure your legal teams in both countries are aligned from day one.